The defense laid out its case today, as we just heard, in the trial of Gerald Stanley. Charles Hamilton explaining that Stanley's lawyers are calling the shooting a freak accident. The 56-year-old has pleaded not guilty to killing 22-year-old Colton Boushie. We are joined once again by Saskatoon defense lawyer Brian Pfefferly. Hi, Brian.
Hi, thanks for having me.
Thanks again for joining us and sharing a little bit of your perspective as you're keeping a close eye on this trial. What do you make of defending the shooting as a freak accident?
Well, it's a lesser known defense that comes up from time to time. I think most of the people that were sort of checking this case on social media before knowing what was going on, we were expecting the focus of this case to be on property rights and defending people's property rights. So in that sense, it's a surprise, but the facts are the facts, and that's what I think made this case exciting for the community insofar as really knowing what the file was actually about, and that's what's interesting.
How do you think this freak accident defense will go over?
Well, it's up to the Crown to prove a case beyond a reasonable doubt, and the burden of proof remains with the Crown throughout a criminal trial, and that would involve a situation where if the Crown can't prove beyond a reasonable doubt that it was not an accident, that's going to be interesting, and if the jury believes the accused on this point, it will lead to an interesting result, and certainly an acquittal will be what the defense would be seeking, and if he's believed on this point an accident, as long as it's not deemed to be criminal negligence or his actions leading up to it are not deemed to be criminal negligence, it could lead to an outright acquittal or a finding of not guilty. So it'll be interesting to see what the jury ultimately does with this defense and their consideration of his testimony.
Is it a strong defense?
Well, I guess that's up to the jury to decide. I mean, not knowing really what's there, it's so difficult to know what pieces of evidence the jury are going to be relying upon. One would think, in many respects, that running a defensive property argument on this would be more likely, and as a result, because it's more likely, people would think that the jury might bite on that sort of a situation rather than an accident type defense. But no one can really predict what the facts are, and many times, as we often say, the truth is stranger than fiction. And if this in fact is the case, again, keeping in mind the Crown has the obligation to prove this beyond a reasonable doubt. The accused does not need to prove themselves innocent. It could definitely lead to an acquittal if the jury believes it. Again, the strength of that defense is going to have to be determined by the trier of fact, which is the jury.
Is there anything that you saw last week, that we learned last week, that could affect how the defense moves forward as it calls more witnesses this week?
Well, I think that definitely there is that flavor still in the background that notwithstanding the sort of accident defense, the Hangfire defense, which appears to be brought forward by the defense, still in the background, I think, will be this issue of were the actions reasonable in the circumstances? Was Mr. Stanley justified in shooting any shots, warning shots or otherwise, toward these alleged intruders to his property? And what was justified in all the circumstances. So last week, I think we got a sense of the potential defenses that are coming forward, and certainly the focus appears to be on this issue of Hangfire rather than defensive property. And going forward, when we see what the closing arguments are going to be, that will really be interesting to see how much emphasis both parties put on this defense of accident, as we would somewhat call it, rather than a defense of person.
We heard from Gerald Stanley's son last week. Why did the Crown call him in a case against his father?
Well, the Crown has a duty to be fair and call all relevant evidence in providing an appropriate narrative to the jury. So when they're calling a case, they need to call all the relevant evidence, and I think that this is a case where the Crown felt it was appropriate and likely fair to do so, and that would make sense that they would call those witnesses which are relevant to their overall case. I know that online there was a number of people questioning whether that was a tactically advantageous decision for the Crown, and I just sort of say that the Crown doesn't win and lose cases. They simply present the facts and present the evidence. So tactical decisions for the defense are treated much differently than tactical decisions for the Crown. When the Crown is presenting a case, they just need to present the facts. And I viewed the calling of Stanley's son as a witness that was potentially relevant to the overall circumstance, the narrative, and calling him was appropriate. And if the Crown felt that calling him wasn't appropriate to that narrative, they should have called him and did so. And certainly my view is any criticism that that created a tactical disadvantage for the Crown is unfair, and I think it undermines what the Crown's duty here is, and the duty is to present all relevant facts and not to simply win a case without that overall fairness principle being considered.
Thanks for your time today, Brian. I appreciate it.
Well, thanks again for having me.